We also passed out a supplement. We want to apologize for the cases on there. Between the snow day and a couple of our investigators getting flus, we had some late reports coming in. We wanted to make sure some cases that were a little older got before you. So if you do need a moment to review those, please feel free to do so. But both Shalina and I are here for questions for anything that we can help address.
Okay. You guys ready?
Yes, sir. Ready.
Okay. I think Commissioner Norton has a couple, and I think Commissioner Galvin has a couple. So let's get right to it.
All right. Good morning, Commissioner Norton. I'm just going to start kind of in ascending order of the pages.
Sure.
And I was looking at one of the very first ones on page 4 and 5. Regarding the penalty for $10,000 for failure to supervise and one act of hiring an unlicensed salesperson. It authorizes a civil penalty amount of $5,000 for a total of $15,000. And I've read this several times, and this business appears to be they appear to be in business for 2 years, and they've only had one problem stem from a bad employee, and no other claims. And to me, I just thought that the more than they did, and they recognized that what happened, and it was internal, and they corrected it. It just seemed like a very severe penalty for the violation.
I'm glad you said that. That's something I was a little torn on in this one. It's one of our first encounters of having a dealership having an employee abuse the Easy Tag system. So I wasn't sure if we wanted to set the tone in this sort of way because of the severity. And this will be our second complaint we've had since Easy Tag started, where it looks like employees have abused that system in some way to print tags. So I was hoping to create a deterrent effect because of the extent of the damage. This is quite, in fact, the conversation we had internally was possibly even looking at a license status change just because of how large of an issue this was as far as the number of tags. But considering kind of what you're saying, Mr. Norton, we're talking about this is a smaller dealership. The owner himself is actually not present a lot. He's actually mainly the mechanic. It's kind of one of those situations where he put a lot of trust into someone that was probably improperly placed. And so I am more than comfortable to reduce the penalty because this is kind of a tone-setting complaint, this one. So I'm open to suggestions. Now, Ms. Hill no longer works there, so that penalty will be separate. Normally, we wouldn't pursue a salesperson all the time, but considering the extent of her fraud, I felt that it was important we have something on her licensing record in case she tried to re-enter the industry. But for the $10,000 with the dealership especially, I think that's definitely something I'd be open to this committee's suggestions on what you think is appropriate in this kind of case.
Yeah, and I agree with Stan. That was one of my questions I had, that penalty was just way too steep.
Well, I mean, going back to some kind of conversation we had with oversight about knockout punches on small dealers, this falls right in that category. You know, I understand setting the tone. There is a responsibility of the dealer to maintain his records, and I got that. I'm a dealer myself, and you can't watch every person all the time. But I think in setting the tone, I think I agree. I think the fine should be less than what's stated. $5,000. I was thinking more like a $2,500, $5,000 total. That's still a substantial fine for a small dealer.
Does the committee agree with the reduced penalty to $5,000?
I agree.
Okay. Motion on that, or do we?
If I could ask, is it $5,000 for just the dealership, or did you want to do it $2,500 and split in half?
$5,000 total.
Perfect. Just clarifying. A motion would be great just to amend this for the recommendation, and we can make that change for the full board.
Okay, good. Okay.
Oh, and to know, Jason made a great point on this case. I've actually already sent this over to Revenue. That's the only reason you don't see a referral there. So just, I think that was a great point by Mr. Gillum.
Ready to move on? Okay. Next one I have is on page 6. Do we refer to these by case number? Or?
You can, or even just the number that it's listed as number 9 on here. These are, we
okay.
didn't.
All right, there you go.
We made sure that there's no two number 9s and this time around.
Okay, there was on number 9. There was just a commission decision. It was left blank, and I was just I didn't know if these were open for discussion. If there's nothing under the commission decision.
That's normally where after we leave and everything's voted on, we'll go back and add whatever the board decides. So the recommendation is still there for you, but we will add kind of if either concur or if there's a change there later.
Okay, all right. And on number 26,
Page 26.
no, item 26, page 13.
Yes.
This is something new that I've seen. It's a compliance plan. And it looks like to me that we were happy to move forward with a compliance plan, but it didn't address the issue that he still hadn't paid the $4,500, and was there a payment plan arranged for that $4,500?
He's actually paid that off as
Okay.
of today.
Do we have a written compliance plan?
Yes, we
Okay.
created one with a previous dealer that was a new dealer just opening and clearly new to the industry. And it's a similar case here where there was many administrative errors, but ultimately no consumer harm. And so that compliance plan we had used was pretty much utilizing that new application that you all approved, the much more detailed one, going through that thoroughly and meeting with the dealer. So that is the compliance plan we've used, is that new extensively detailed application.
If there's any new information, I'd like to see it. I think that's a great idea. 'Cause
Absolutely.
I think education is important for these dealers to understand what they're supposed to do, especially when they get in trouble.
That's something I think we hope to utilize going forward, especially when you see a repeat offender where it's really a paperwork error. So we're going to try to do that more often. We've seen great success on our first dealer that we did that with. We haven't had a complaint since. So I think that hopefully it'll work.
That's certainly the goal. Okay, item number 35 on page 17. We have there's one line item here that got my attention. I think we issued a letter of warning, but one thing that was not addressed is the fact that the complainant used a dealer tag for 1 month while the issue was resolved. I mean, there was no mention of that being a violation of using a dealer tag on a customer's car in lieu of a temporary tag.
Right. There's a question I have for the commission. I've seen it where they can use a tag on a vehicle when they have a vehicle for repair, and I didn't know if it was industry practice to do that or not. So I was unsure on that because the dealer tag exception had allowed it for using it on a loaner vehicle in the meantime while they fix the car. So I wasn't sure if okay.
I would challenge that. I mean, I think this is a clear violation.
Perfect.
So anyway,
Are you saying that?
no, you can't put a dealer tag on a customer's car after it's already been attempt to license and they've purchased the vehicle. They don't own the car; they own the vehicle. The dealership, the dealer tag goes with a company-owned vehicle, not something an individual bought. So
That makes sense to
Yeah.
me. Is that something you'd like to do a violation on or include in the letter?
I think it would. It's certainly a violation. Whether the penalty, there was other issues here, not related to the tag, but it's certainly worthy of notice. Those tags are a privilege, and they're not to be abused.
Concern also to be noted is the liability associated with it, and if the vehicle was involved in an accident during that period of time, which coverage would actually cover the vehicle. So that's a very astute comment.
That's a statute. I mean,
Right.
yeah, that's a statute.
It's a violation, but I mean, I don't see why we couldn't send a letter.
I'll make sure to
Happens
include that.
again, let's go ahead and do the.
What the recommendation is, a letter of warning.
Isn't it? But not related to the tag.
Oh,
not
okay.
related to the tag.
Right. I'll make sure to add a language about that and cite the statute about use of dealer tag on that one. I appreciate that. Thank you, Mr.
Yeah.
Norton. That helped me too.
Okay, on page 25, item number 54. It's just there's only 2 sentences in this, so maybe something that staff could clear up pretty quickly, but we're going to find this to be more common with e-commerce and certainly with Amazon and other dealers coming in. It states that this vehicle, this dealer had a license in New Jersey, not in Tennessee, but at least 25 vehicles were identified by the county clerks that have been registered after respondents sold them in Tennessee since 2016. That itself is not a violation. If the cars were displayed in Tennessee, however, that's a violation. It didn't clear that up. I've registered cars all over the United States in different clerks' offices, but we sell them based out of licensing in Tennessee. And I didn't know if the investigator found these cars were actually always here in Tennessee and sold from Tennessee.
We know he's here. It seems likely that he is selling them in Tennessee, but we do not have, all I have as far as proof of actual sale are the registration VIRs and then the county clerk. So you're correct that there is a little ambiguity going forward that I would hope to flesh out in the discovery process. But if you think that at this point we may not have enough, I would defer to the
It would clearly depend on where those cars were located and presented when they were sold. If they were in New Jersey, it's not likely. I mean, if they were in New Jersey and they were sold down here and shipped down here, and then there was a lien put in place, then that's an entirely different story. Yeah, well, we don't have the facts, and we don't know. Okay. So where does that leave us with a fine on this particular case? Are we going to further investigate?
It was my right.
Okay.
It was my looking at what I had. It seemed more likely than not that these vehicles were being probably purchased at Tennessee auctions. I talked with the auction access folks, and they said that the auction access for this individual was here in Tennessee. It seemed more likely than not that they were displaying and selling in Tennessee. And in fact, this is not all the cars registered. We have
Okay.
registration history
I
all the
got
way
you.
back. So you're right. More discovery will probably
Right.
ensue as we go forward. But if he accepts the consent order as is, I think he understands that he's selling cars here.
Okay.
So that was kind of
Looks likely, but just
Yeah.
didn't know for sure.
It's circumstantial for sure, but it's strongly circumstantial.
Clarification on page 28, item number 62. This is looks like a unlicensed dealer in the state of Tennessee, continuing to continue to sell vehicles. I mean, is there something in place? I mean, looks like we fined the guy $5,000, but looks like there's no stopping. Is there something in place to stop someone who curbstones and doesn't appear to care? They just keep paying fines?
Well, we're hoping we get their attention is the main thing. I mean, I could have easily just overlooked this and closed this because they're not responding, but since they're still operating and conducting these activities, I felt it was important to up the ante, too, in terms of the penalty and try to get their attention, and, you know, because they're not coming into compliance.
If there's a follow-up to go along behind this, to
Yes.
make, okay, all right, that's fine.
Important to kind of help with that too. After we get enough complaints, we often are authorized in our legal office to go forward with the DA and the AG to try to get some sort of injunctive relief. So that there are other mechanisms outside this department. If we stack enough proof, the board's tried to get their attention and they've ignored us. So to kind of help with that side of it.
Robert.
Point of order, Mr. Chairman. It seems as though we have fined $1,000 for open titles in the past. I think we should be consistent. This one's $500. I don't know if anyone has a history here as long as I have, but it seems it was $1,000.
Chairman Roberts, this is actually not a dealer.
Unlicensed dealer, yeah.
Unlicensed dealer. This was not a dealer that had a license and expired. This has never been licensed.
Correct.
Does that matter?
Yes.
I mean, as to the amount of the fine. I'm sorry. Open titles.
I think the commission has an approved fee schedule.
Yes, and this penalty is not for the open titles.
Oh,
Licensed sales activity. Unlicensed dealer.
Sir.
okay, so he's not written up for open titles. He's written up for unlicensed activity.
Yes, sir.
We can only penalize folks with licenses for the specific violations of our statute. Because becoming licensed, you're then therefore held accountable for the elements of our statute. But if you remain unlicensed, the only thing that we have access to is to say you should have had a license so that we could regulate these things, and you didn't do that. And so that's why you'll see often our unlicensed dealers have a slew of things that would be violations if they were dealers, but what we can only focus on is the fact that they're doing all that off the books as an unlicensed dealer. I don't know if that helps, Chairman, but
So an unlicensed dealer can sell on an open title.
we couldn't hit them as our part as an administrative violation here. We can only hit them for not having the license.
Continues to violate the statute. Yes, this is more than one offense. That's why the penalty is high.
Think upping the ante is going to cure that problem with him?
I hope so.
Here Curiosity, what happens if he doesn't stop? I mean, he may be make enough money, he can pay the fine.
That's my point.
Yeah. What's the cure if he never stops?
That's kind of what I was saying a second ago, Mr. Norton. After we get so much proof that we have a situation of a habitual repeat offender that violates the law, our law encompasses that being unlicensed is actually a misdemeanor charge. At that point, we can go to the local DA for this area or the Attorney General's office and seek injunctive relief, and they can also bring criminal charges if they so choose to. Often that's rare, but if we get enough proof that someone is openly defying this board and its orders, that's when we can start to look to the courts outside of our department for an injunction.
Typically, what we'll do is we will refer these to the DA with all our proof, and if they have enough resources and are able to, they will pursue the matters. It happens often with contractors, so.
Like there's been a general poaching of our industry as far as curb stoning and unlicensed sales activity, and this really leaves the consumer in a bad way because there's no way to protect the cases before us. But I think it's worthy of following up on. It's an interest to this commission, I'm sure. Let's see. On page 40. Item number 84. I think I read this one probably 5 times to try to get a grasp on the scope of what's going on here. Basically, I think if everyone's read it, it's just maybe. Yeah. Page 40. Well, maybe you're right. You're right. I skipped the page.
92.
My bad. It carried over other pages. I guess that's why I cut it off. But after reading this, the previous recommendation was revocation of license, and it's open for discussion. I think this one's wide open for discussion, but I'm okay, but there's pending investigation. There's still some issues to be resolved here. At very minimum, it'd be a suspension of license until the investigation. This clearly looks like a bad dealer. I'm asking the staff open for discussion. I think something needs to be done.
Sure. In this case, just to kind of give some context and bringing it back, before, when we decided revocation, I actually hadn't heard from this dealer because his criminal attorney had advised him not to participate just because of the possible implications. So now I have a substantive response, and really they just pointed out the reduction in the misdemeanor that was assigned to him and whether we felt that was comparable to revocation or whether it warranted revocation. Additionally, the complainant in this case is very active in this case, has gone through and kind of scoured the internet for similar complaints and provided those to me, and I had those investigated. The investigation did come back, and at this point, none of those individuals online, either we were able to locate or contact or were willing to participate in our investigation. And so the respondent is asking to be able to maintain their license in some way in light of the fact that they claim that they didn't tamper with the odometer, but rather didn't note the original mileage on the inside door frame as this being a misdemeanor. Considering there was new information in the form of him responding and then the follow-up investigation, I thought it was worthy to bring back to you. But it really is in the discretion of this commission. I think that a suspension is warranted, but I also think you have a defense for revocation. So I wanted to see if the fact that it's a misdemeanor and him pointing it out and that I couldn't find anything changed your opinion one way or the other. I didn't want to proceed forward without you all getting one more look at it with all that new information I had received. So I'm open to however you think is appropriate to move forward in this case.
There's still more to be determined on the investigation. So
I definitely agree.
But
At this point, there's not anything further that's being pursued. If it's in here, I apologize. It might be left.
Okay.
I got the investigation not terribly long ago into our additional complainant possibilities. None of those folks ultimately filed a complaint with us or participated in the investigation process. So that investigation did take quite some time. Our investigator did what he could to try to find folks, really just from, Better Business Bureau complaints and things like that. but we weren't able to get anyone additional. So at this point, everything is closed. The criminal case is closed. He's participating in the probation he has and this service. So at this point, there's nothing further to look into. We kind of have what we have.
Have a recommendation?
My recommendation, I am semi-persuaded by the fact that he was ultimately charged with only a misdemeanor. I try to think about it as far as if I were outside of this department and I got a Class B misdemeanor and then I was closed for it, whether that was appropriate. Obviously, the underlying misdemeanor, it goes straight to the heart of being a licensed dealer, which is why I think that there is a way to say this is the reason that even though you got a criminal misdemeanor, it's a harsher punishment from our commission just because of the nature of the misdemeanor, if that makes sense. But I think that's why I'm comfortable saying that if you wanted to come down from revocation, just in light of the fact that they reduced the penalty in criminal court to a misdemeanor and then moved away from odometer tampering and instead went with deceptive business practices, it may not be. I think you're fine either way. I truly am deferring to you. I think that it's defensible as revocation, but I see the argument on why you may want to reduce it.
And I asked you, does the staff feel like this dealer is a threat to consumers going forward based on all the facts you found?
If those additional complaints I investigated came back with someone participating, I would have said yes. But at this point, I can't get another consumer to reflect what this consumer experienced. Additionally, we have the second complaint that has to do with mechanical, but nothing really came out of that investigation either. It was an as-is sale and a buy here, pay here lot is difficult. I think we have a very aggressive complainant in this case that is pursuing this matter. She specifically wanted me to tell you that she is adamant that you close this dealer and felt that he was a threat to the public. But at the same time, he's also paid that complainant back for the truck in full, gone through the criminal process, and has been disciplined in that way, and we haven't had additional complaints in the meantime. And so, their argument is that this was all a misunderstanding on paperwork. Kind of getting outside of consumer protection to the actual case itself, the proof in this is a little difficult. Obviously, we have two good witnesses in our complainants, our purchaser and her son. Those are witnesses. But we do have a signed odometer disclosure statement, and it's a he said, she said about what happened when they signed that odometer statement. So it's a difficult case evidence-wise, I'd say. I think that's probably why you see the plea in the criminal court. And we do have, at least online, a history of people having frustrations with dealers. But, to be honest with you, there's not many dealers I look up online that I don't see that. Obviously, we have a lot of more mechanical issues you'll see here with as-is sales. That's a concern of mine for sure. And I think the fact that there was a misdemeanor levied related to his business practices is important for this commission to take some action on. But whether I think he's worth shutting down, and whether I could prove that in a hearing, I'm a little hesitant. I am hesitant.
I'm skeptical of this whole scenario, but I personally don't think there's any way that we revoke his license. I don't know, but that's just my opinion.
He's doing the right thing. He paid it back. The money's back. I mean,
I'd also look at the history. I know this dealer has had a little bit of a history as well prior to this complaint. So I just wanted to point out that was on your report in case you had any questions of legal regarding
I believe
this.
the $8,000 was for unlicensed activity. That is just my remembering, so I don't want to be quoted on that. But I'm pretty sure that was for unlicensed activity, and then they became licensed after that date. And then you see, obviously, we had earlier this misuse of a dealer plate and possession of open titles resulting from an NOV that we had pursued. That's another hard one. It's a big penalty, but he also came into compliance, so it's one of those.
That didn't directly affect the consumer either.
Yeah.
So that's
Right, this is not the first time they've come before us.
Some sort of penalty rather than a revocation of a license. What a penalty? What would be the thinking of a penalty for?
Sure. I think if we were to couch a penalty, it would be a false, fraudulent, deceptive act. Obviously, we have an incident here where it even resulted in criminal charges. So you may want a max penalty of $5,000. That's usually what we go for. It'd be one act, so one $5,000 penalty.
tend to agree with you because we see a pattern, even though he's trying to do the right thing. But if you hit him with this $5,000, the pattern could probably it would open his eyes.
I think so. I think that also the vehicle that he ended up having to repurchase or pay back the $32,000 definitely hurt. That's definitely a point.
I'd like to make a
point
motion
made.
we fine him for $5,000.
Second. All in favor of the motion, signify by saying aye.
Aye.
Ayes have it, so ordered. Motion carried.
And this dealer's worth watching, too.
I definitely agree. If you'd like, members of the commission, we could do an additional investigation following this, just to make sure everything's in line as well.
That's a good idea.
I'll request one.
Let's see, I just had a, no, I'm saving that. Item 95 on page 43. Let's see, and this is, looks like the sale of 5 vehicles at a car show. And there was a unlicensed vehicle for sale, unlicensed dealer location. And I just had an observation. Do we check to make sure that those titles were in the respondent's name as a dealer, or were they open titles? I'm just curious on that, and if you had any information on those titles, and if that was relevant.
No, he is not acting as a dealer, just as an individual.
Okay, so it doesn't matter. He was just in violation, period. Okay. All right, the last thing I have is item number 97. On page 44. It just, this respondent's not concerned about curb stoning, and it looked like to me that it was things were lightened here just by the mere fact that this respondent was supporting a disabled child. And I didn't know if there's any, I mean, I've got a heart, but I mean, I didn't see the relevance to that and then the violation.
I spoke with this respondent several times, and he's very concerned about this violation, and he made a plea that the board reconsider this matter. He was not aware that it was a problem, exactly what he was doing, and he feels as though the clerk's office just expressed their opinion in stating that he was not concerned about curb stoning.
Okay, that's the statement I was looking at when he said he wasn't concerned. I thought, well, he needs to be concerned. He's not supposed to do that. Okay. He wishes not to continue curb stoning. Is that's what you're saying?
Yes, my understanding, he will not continue in this type of activity.
That's all I've got.
The commission, Gavin.
Question on number 85, page 37. With the previous history with this dealer, I was by the statement that the respondent indicated that the document was signed by a member of his staff without his knowledge. Is that the consent order, or is that the document that's at the heart of the dispute?
It's the heart of the dispute document. He said that he had asked one of his managers to take care of getting that transaction done, and that person then executed the power of attorney, and that they've now let the employee go. It's a gift. It's definitely taking their word for it on that, but I
think I could understand a reduction of the penalty for maybe a person that didn't have quite the history of this dealership. But I was just curious about the willingness to negotiate a penalty based on his past history.
I definitely agree. This is one of those situations where I have an opposing counsel who made a formal settlement offer and then brought forth the evidence about having the disconnect in the sale between the owner and then the let go of the employee. But we hear that a lot. So as much weight as you want to give that, I think is kind of up to your individual experience. But more often than not, you'll hear that the issue rose from some employee that no longer is there. So I wanted to bring that settlement offer to you. I didn't think it was necessarily unreasonable, but I agree with you. If we need to maintain in light of the history, I think that is more than acceptable.
So it's really a litigation decision of something that's being offered on the table right now. How much more effort do you want for an extra $2,000? So sure. I'm fine with the reduction, with that explanation.
Page 8, I'm just for clarity purpose, number 13 and 14, are those different? Are they the same?
Those are the same respondent.
Okay. I was wondering if it was being duplicated or not, but that's the same respondent. Okay.
Oh, I think you're right. It is a duplicate. I
Thought so, that's
apologize. Yes, what I'll do is copy and paste to kind of get the format, and I must have just skipped right over it like it was already there. Thank you so much, Mr. Jackson. I'm sorry about that. Because normally I couch my respondents under one title, so I was even looking at it wondering why I had done it that way. I usually like to do complaint 1, complaint 2. So thank you for catching that. I appreciate it.
Also on page 27, number 59 and number 60. I think they are the same also.
No, these are two different.
Two different ones? Okay. Okay. All right.
They look similar, though.
They definitely look similar. Okay. And over on page 29, number 64. Where the complainant was given the respondent bonding information. I just wanted to ask, could we flag that one?
Yes, sir.
Okay. Also on page 31, number 69, just a recommendation. I think we need to flag that one also. Anyone else? Okay.
Y'all reviewed the supplement? Okay.
sir.
Okay. Do we need to do a motion, or do we defer to the full body?
If you'd like, you can do a motion to recommend with your changes to the
Changes,
full
okay.
body. I think that might be nice.
Do I have a motion to recommend?
Yeah, I have a motion to recommend we adopt the changes on the legal review this morning.
Second.
All those in favor of the motion, signify by saying aye.
Aye.
Any opposed, ayes have it, so ordered.
Much. We really appreciate you.
Thank you.
Thank you, Chairman Jackson. The commission will adjourn in 10, will begin in 10 minutes. Adjourn. Excuse me. Ms. Shaw, would you call the roll, please?
Chairman Roberts,
Here.
Commissioner Lee, Commissioner Galvin,
Here.
Commissioner Clayton. Commissioner Clayton's notified us that he is out due to the flu. Commissioner Fox. Commissioner Kramer.
Here.
Commissioner Jackson.
Here.
Commissioner Melton.
Here.
Commissioner Murray. Commissioner Norton.
Here.
Commissioner Vaughn. Here. Commissioner Tomaso.
Here.
Commissioner Levy.
Here.
Commissioner White.
Here.
Commissioner Evans.
Here.
Commissioner Barker.
Here.
Mr. Chairman, we have a quorum.
Thank you. All the proper meeting notices made, I assume. So we'll, if you'll look at the agenda for today's meeting, we're looking for an approval of that or changes if necessary.
Jackson, motion to accept the agenda.
Second.
Motion to accept the agenda and seconded by Commissioner Galvin. Norton. Vaughn. Sorry. Commissioner Vaughn. Any discussion or concerns? Hearing none, by voice vote, those in favor of the motion to approve the agenda, say aye.
Aye.
Those opposed, say no. Motion carries. Okay. Minutes have been circulated from the last meeting of October 23rd, 2017. If you've had time to look at those, we'll entertain a motion to approve or changes that might.
I want to make a motion that we approve the minutes.
Commissioner Fox, motion to approve the minutes. Seconded by Commissioner Barker. Questions or concerns? Hearing none, chair calls for a voice vote to, for the motion to approve the minutes from October 23rd, 2017. Those in favor say aye.
Aye.
Those opposed, no. Motion carries. Ms. Shaw, we've adopted this mission, I believe, mission statement, haven't we? Yes. Okay. Do we, on the agenda, do we want to read it into the record or just acknowledge that we have it?
Acknowledge that we have adopted it, 5517-101.
I won't ask for further action, but we'll acknowledge that we have adopted it. All right. Then we'll move right into the salesperson and dealer appeals.
Chairman, we need to read the meeting notice into the minutes.
Okay.
Okay. This meeting's date, time, and location have been noticed on the Tennessee Motor Vehicle Commission website, included as part of this year's meeting calendar since July 24, 2017. Additionally, the agenda for this month's meeting has been posted on the Tennessee Motor Vehicle Commission's website since January 18, 2018. This meeting has also been noticed on the tn.gov website. Thank you.
That done, we'll move into the appeals. First appeal would be Troy Scott Carter, Gray Epperson Automotive, Cleveland, Tennessee.
Chairman Roberts, I
Yes,
need to
ma'am.
recuse myself, please.
Okay. Thank you. For the record, Commissioner Melton recuses. Morning, sirs.
Chairman Roberts, if you would allow legal to read a brief excerpt from our memo before each appeal. Thank you. In the case of Mr. Carter, the documented conviction is for interstate transportation of securities taken by fraud on August 13, 2015, From the documents that were submitted to the Commission, it appears that the applicant received a sentence of 34 months in prison and approximately 3 years of supervised probation subsequent to the completion of his prison sentence. It should also be noted that the applicant was charged with over $889,000 in restitution. Application may be denied under Tennessee Code Annotated 5517-114A1C until approximately August of 2026.
Carter, would you give us a brief overview of how this event happened?
Yes, sir. I in 2010 and 2012, I was in business with someone, and he and I were doing some things on the backside. Basically, it was almost like a kickback. At the time, I didn't realize it was. I mean, I did it. I admit to it. I didn't realize it was as. I didn't realize it was the wrong thing to do because it had been done for many years before me. But it doesn't matter. I was wrong, and I did it. And so as a result of that, I was convicted, and I was sentenced to 34 months. I went through a pretty intense cognitive behavioral program that I volunteered for in the federal system, and I was allowed to. My sentence was reduced as a result of that because I passed that that very intense 9 months of cognitive behavioral therapy that was a 24/7 thing, and learned a lot about myself, learned a lot about and taking responsibility for the things I've done, and so I have paid a considerable amount of money has been paid back. I still owe them, and I still continue to make restitution every month on a monthly basis. But yes, sir, I was convicted and I was wrong, and now I'm just trying to. I held automotive license in 2014 and 15, and I worked for a company that Mrs. Melton's father owns, and so I've been in the car business before that, and so I just wanted to come back and try to just be a responsible citizen and do what's right and continue to pay my debt. Although I've served my time, but continue to pay my debt that I owe, and just be honest and make an honest living.
Questions from the commission for Mr. Carter?
I'm still not sure what you. I mean, I see the dollar amount, but I still don't understand what happened. How'd you take the money, and who'd you take it from?
They were through hotel contracts, and so the gentleman that I was working with, or that we had hired, on rebates, and the rebates came back to him, were made payable to him, and he then I would get trips out of it, cash at times, and so forth, so on. So it's basically, I mean, it's kickbacks, and it's against the law, and it was defrauding the people that I work for, and so the government said that money should have gone to the people I work for instead of me, which is true. So so that's what I did. But like I said, it was cash, it was trips, it was various things, but it came up to about, like she stated, $889,000 over a 4-year period of time. Well, 2010, 2012. Sorry.
What was the actual commodity, sir? What were you selling, or your?
It was it was a convention for a church organization. We were selling church hotel rooms and things of that nature for their convention, and then on the back side of it, you get rebates, and so the gentleman who was signing the contracts got the rebates, and as his client, he was padding my pocket on the backside. It's against the law.
Sorry, Commissioner Levy, one question. Did you work for the church?
At the time, I did, yes, sir.
Okay. So this is the fourth time. I think the main part of what we're trying to do here is to understand what happened, understand if we can trust you to
Sure.
interact with consumers. So for the fourth time, can you just try to summarize what your role was, who you were working for, what you did, why it was against the law, and why that's not going to happen again.
Yeah, I worked for the Church of God International offices. I was a director of communications and public relations, and as in that portfolio, I was also I did the meetings. I planned all their big events, so to speak, and I had another business on the side, and I got into business with someone that I shouldn't have gotten into business with, and I made a very honest living, a very good living, lost a lot of money, and he was basically helping me on the backside to try to recoup and try to live again. But yeah, I lost everything. I lost my family, I lost my girls. I have 2 daughters. One is 22 and one is 19. I have no relationship whatsoever with them. I was married for 25 years. So my wife divorced me. And I learned a very, very valuable lesson. I took those rebate monies that should have gone to the organization, and instead I took the vast majority of them and was trying to recoup and to live. And I was wrong. Since then I've been out for a little while now, and I worked in Georgia. I was a sales manager there. I did very well there. They trusted me. They knew everything up front, and I was very honest and forthright with them. And then I just wanted to come back closer to Tennessee. Well, come back to Cleveland, so hopefully that I can have a relationship with my children one day. Like I said, right now I don't, but I still hope and strive for that, and trying to do everything I can to be honest and be upright and forthright, and gain their trust again one day. But in the meantime, I'm just trying to make an honest living. I enjoy the car business. I did very well with it, and again, just want to try to start life over again. I don't have, as far as interchange with money or anything. Mr. West here is a GM there. I have no access to any of that. I don't want it, but even if I did, I wouldn't. I'm not going there. I've already been there and done that. I'm not going back, and for any reason, for anybody, for anything. Did that answer your question, sir? Yes, sir. Yes, sir.
Further questions?
Commissioner Vaughn, have you been in any trouble since this?
No, ma'am.
Okay.
That was first and only ever time.
Okay.
Commissioner Galvin, on my tablet, I'm noticing a lot of white spaces with no wording. Is there?
Is it blank pages?
It just blank pages. It picks up when you scan, when it was scanned.
No further questions at this time. Did you bring someone with you, sir?
This is Mr. Billy West. He's our general manager.
Okay.
Yes,
We'd like to address the commission on behalf of Mr. Carter.
Yes, I'm the general manager of Gray Epperson Automotive in Cleveland. I've been employed with Gray for 10 years. And I've known Scott. I'm born and raised in Cleveland, Tennessee. I've probably known Scott 15, 16 years. He's an upstanding citizen. He did make a mistake. I will say this, though, coming to work for us, he's coming to work as a salesperson, so he's not going to be in the finance office or making any upper management decisions. We have checks and balances in place, and I feel like that he would be a good addition for our company, and I do truly believe that he has paid his debt to society. He understands that he did something wrong, and I think he's just looking for a good place to work where he can start over again. And like I say, several people in our community, business owners, know Scott. He's well liked in our community. Even with this shadow over his head, even back in the community, several people, business people, know and they respect Scott, and so again, we just ask for your leniency and just that you would give him a chance and for him to continue to try to rebuild his life. That's it.
Questions or comments at this time? If we don't have any, we'll move on to. We'll call for a roll call vote. Oh, well, we don't have,
Motion
sorry,
first.
we got to have a motion of some type first. I needed that second couple.
Chairman, I'll make a motion that we grant him his license.
Second by Commissioner Vaughn.
Motion to grant by Commissioner Fox, seconded by Commissioner Vaughn. Now, is there any discussion of the motion? This time, we will move for a roll call vote. Ms. Shaw. Yes would be for the motion to grant. No would be to not grant the license. Ms. Shaw.
Commissioner Levy?
Yes.
Commissioner White?
Yes.
Commissioner Lee?
Yes.
Commissioner Barker?
Yes.
Commissioner Fox?
Yes.
Commissioner Galvin?
No.
Commissioner Norton?
Yes.
Commissioner Vaughn?
Yes.
Commissioner Jackson?
Yes.
Commissioner Kramer?
Yes.
Commissioner Evans?
Yes.
Commissioner Tomaso?
Yes.
Chairman Roberts?
Yes.
Motion carries to
Motion
approve.
carries. Congratulations, sir.
Thank you. Thank you all.
Michael Armour, Jones Chevrolet, Humboldt, Tennessee.
Commissioner Roberts, I need to be recused.
So Commissioner Kramer request to be recused.
In the case of Mr. Armour, the documented conviction is for insurance fraud, identity theft, and arson on March 1st, 2010. Applicant received a sentence of 8 years prison time with an early release date of September 21st, 2016. Application may be denied under Tennessee Code Annotated 5517-114A1C until September 2021.
Armour, would you like to give us a brief overview of how we came to this place?
Yes, sir. In 2010, I was convicted of arson and identity theft and insurance fraud. I'll give you a quick overview of it. I was working here in Nashville for SunTrust Bank. I was a financial service representative at SunTrust at Work coordinator. I ended up moving back home to Jackson, Tennessee, where I built a home there. I was out one night riding my bike. I had some candles lit at my house, non-scented candles. My house didn't burn down, but some property in my house burned down. After that, my insurance company called me, and I had an insurance claim on my property that burnt down. The claim was $1,000. It's what they gave me till everything else was going through the system about how my house burned down. I went to court, filed in court, ended up taking a best interest plea with insurance fraud and arson. They said there was motive because I left candles lit and I wasn't home.
There was another account. This was the arson part. Is that all three charges were related to this one incident?
The arson and the insurance fraud. What was the other one?
Identity theft.
Oh, yes.
Yeah, why the identity theft?
The identity theft was there was a credit card that me and my auntie both had, different accounts, and somehow it was tied into mine. We did contact Visa, which it was through SunTrust Bank, where I had a credit card and she had one. I had no access to her credit card at all. When we contacted Visa, my lawyer and I, and they had no nothing to say that I had called in, added my account, tied my account to her. There was a password on the account, which my aunt. I'm tied to her by my uncle. Ended up marrying her, and that's how she was my aunt-in-law. And the password, when we called Visa and we was trying to figure out all how that's happened, Visa was said that it was a lady that called and had it tied in. They have no replication of me calling or anything, so we didn't know what went on with that. But towards my plea, they added all three in together.
So all this, except for the credit card, all this stemmed from the candles at the house and the accidental fire, but you were convicted of insurance fraud, and the claim was only $1,000, and then you were incarcerated.
Yes, sir. I was incarcerated for 18 months, which ended up, 18 months, 2 years. And I was put on parole and probation, which I completed in the institution. So I got out on early release with completion of my parole.
Did you have a public defender, or did you have an attorney that you hired?
An attorney.
Questions by the commission?
Commissioner Lee, first of all, when did you get out, and what have you been doing from that time forward?
I got out in 2016. And since I've been doing that forward, it's just been definitely taking care of my kids. I've been working different jobs through temp services, stuff like that. I started my own business. I was running my own tree service and did very well in that. But sales, since banking and stuff, sales have been my life. That's what I know. That's what I'm good at. Since then, since 2009, I've not been in any trouble, not ran into any police, not even have a driving ticket. So I am a law-abiding citizen, and just been going straight forward since.
The credit card part, I had difficulty. I'll admit to having difficulty in following, but if you were in banking, I don't understand knowledge of credit cards and how they work, so as to not have a problem like this.
That was one thing when I was going to court. We all couldn't understand how it happened. There was no way that her credit card could be tied in with my credit card without somebody adding me in as an authorized user of her card.
Question: Did you spend money on her credit card?
I spent money on my credit card, but it was tied into hers, so it also went into her account also. It was linked. The credit cards were linked in together.
Okay. Gentleman that came with you like to address the commission. Sir, would you like to address the commission?
Ms. Paul Hayes, I'm General Sales Manager of Jones Chevrolet in Humboldt. I met Mr. Armour approximately a year ago. We spoke briefly. I met him again about 4 months ago. Recognized him. We were having lunch. I asked him what he was doing. He said he was doing his tree service. He said he really liked to get in sales. So I offered him to come have an interview with me. He sat down a couple of days later. I hired him on the spot. We applied for his sales license. It got denied, and we applied to show up here today, and that's why. I know Michael. I know a lot of people that know him that I've known for years. I fully trust him. He's got 3 young girls. He's married. He made a mistake. He paid for it, and I think he would be a significant asset to our dealership and also do well for his family and himself.
Any questions by the commission?
Just a point to note for the commission and any questions you might have following this statement. From the information that was submitted by the applicant, we do show that his conviction for insurance fraud was in the range between more than 10,000 and less than 60,000. Just wanted to make that note.
Mr. Armour, your disclosure to us, the commission, was that it was $1,000.
The insurance fraud, yes, sir.
Okay. Now, what's the difference in what Ms. Goldstein just read to us?
Question is, if the claim was for $1,000, why'd you plead guilty for a claim of $1,064,000?
That was the property damage of when my house burnt down.
Property damage to the house?
No, sir.
This again is a little hard to follow. And Mr. Armour, we're not here to retry your convictions. That's not the purpose of this. I think what the commission seeks out is credibility and some consistency in a behavior that gets you back toward you can be trusted with a salesperson's license. So we're hearing $1,000 and we're hearing $54,000 and these things just sound aren't quite adding up yet. I mean, if you're convicted of insurance fraud, why would you defraud only for $1,000? And then yet record that it was between 10 and 60, I think.
Right.
Is the conviction?
I think we're looking at two different charges.
Okay.
My insurance fraud was $1,000. Now, when I went to court with my property damage, that's what they said it was all together for my property. What the insurance company cut me a check for $1,000. But the property damage of the house was, again, what the lady said. It was in between, I guess, 10 to whatever it was.
60, I think it was.
60.
Yes, again, 10 to 60. That's what they're saying in total was my property damage with my house. But the insurance fraud part was $1,000 because that's what the insurance cut me was $1,000 check.
For the commission's reference, I'm referring to page 11 out of 15 on the information on your iPad.
What size claim did you file with the insurance company? Was it excuse me, what was the amount of the claim that you filed with the insurance company?
When I called the insurance company, I just told them definitely, what happened and what my house burnt down. But when they came to see me, it was Travelers Insurance. When they came to see me, it burnt all my clothes, bedding, and inside my furniture. And he said right now he cut me $1,000 so I can have, get some clothes and stuff like that. And then it never went past there. So what I received from him was $1,000.
Jackson, did the insurance company repair your home totally from the burn?
Yes, sir. Years after, yes, sir.
That's where between the $10,000 and $64,000.
Yes, sir.
I assume that's where that comes in.
Yes, sir.
File a complaint. I mean, did you make a request for the insurance company to pay for all that property damage?
But when I called them, yes, sir. I explained to them what happened, and when they came, they didn't give me any amount, towards the damage or anything. They just cut me $1,000 to, for my clothes and stuff like that. So I never really got to, after that, I never just really got to talk to them, about how much it was.
Another question, did the court find you guilty of the fact that caused the entire damage? Did they find you guilty of that?
I took a best interest claim, but best interest plea, but yes, sir. I was definitely guilty. I left the candles lit and I wasn't there.
Fraud of the insurance company, that's where the court said that you defrauded Out the insurance company because you deliberately left the candle lit in
Yes,
your
sir.
home.
And that's where the $1,000 came in. Yes, sir.
Commissioner Vaughn, I have a question about the theft. How much was charged on the credit card?
I think 5,000.
Have to make restitution?
Yes, ma'am. I did.
Have you completed that fully?
Almost.
Okay.
Almost.
But you're still making payments?
Yes, ma'am.
Okay.
More questions? No more questions, would there be a motion?
I'd like to make a motion that we uphold the denial.
Motion to uphold the denial, Commissioner Vaughn. Seconded by Commissioner Lee. The discussion is up, the motion is up for discussion. Any discussion or comments? Vote for yes will deny the application.
Commissioner Levy?
Yes.
Commissioner White?
Yes.
Commissioner Melton?
Yes.
Commissioner Lee?
Yes.
Commissioner Barker?
Yes.
Commissioner Fox?
Yes.
Commissioner Galvin?
Yes.
Commissioner Norton?
Yes.
Commissioner Vaughn?
Yes.
Commissioner Jackson?
Yes.
Commissioner Evans?
Yes.
Commissioner Tomaso?
No.
Chairman Roberts? Motion carries. The denial is upheld.
Mr. Armour, the denial has been upheld, but you may reapply later on. And if you choose to do that, just contact the staff.
Yes, sir.
Thank you, sir.
Thank you.
Thank you, sir. Megan Wemple. Wemple. Ms. Goldstein, would you read for our memo, please?
In the case of Ms. Wemple, the documented convictions is for a violation of the Drug-Free School Zone statute, Tennessee Code annotated 39-17-432, for conspiracy in regards to the controlled substance of methamphetamine, 26 grams to 299 grams, on December 13th, 2012. Applicant received a Class B felony and 8 years of supervised probation. Application may be denied under Tennessee Code annotated 55-17-114A1C until December of 2025.
Wemple, would you give us a brief overview of the occurrences that brought this conviction to you? Let me move you a little forward to the mic, please, ma'am. When you see the red light on, you're close enough.
Can you hear me now? Okay. Sorry.
Do you need it moved down, or can
Okay.
we help you in some way?
Pull the mic closer to
Oh.
you. It'll move.
Oh.
Yeah.
Okay.
It won't break. We're both going by
Sorry.
now.
I was about 24 years old, 25, just hanging with wrong people. I was at the very, very bottom of this situation. Basically, they had gotten me along with a lot of other people. It was a wiretap situation, and they were wanting people to testify against the main person. Then I went to jail and did rehabilitation. I was doing marketing and went to school for marketing, Ashford University online, and started to, I guess, not make so much money because it was, the city's growing, so it was very saturated. I started doing detailing cars at Car Concepts about a year ago, and I've moved since then to Ride and Drive, and they've actually given me a chance, and I would just ask to get my salesman license because it gives me an opportunity to go so much further.
The memo states that you were in conspiracy. Does that mean you were selling?
That means that I was benefiting from the selling of, yes.
As in a school zone?
the school zone being between here and Atlanta, because it was being brought in from Atlanta. It was GPS tracked, so on and so forth. You know, there's a bunch of school zones between here and there.
Here in Atlanta.
Atlanta.
Between
It got thrown out, the Class A, because now it's a Class B.
What was your role in the conspiracy?
Really, I was just around the wrong people. I was just knowing of, basically.
Have any benefit from the sale of the methamphetamine?
Not really, no.
Go back to that school zone part, because it would be of concern, a special concern, if you're selling this stuff on to children or something like that. But how would we get back to the school zone between here and Atlanta? What does that?
Okay, so.
And I realize that was pled down, or not pled down, but anyway, that's not what your conviction was. But what does that mean?
That means that I guess he had brought in the stuff too. I guess when they GPS tracked him, it was to a school zone. Like his house was in the school zone. The guy, the main guy.
It helps members of the commission have a little experience with this from previous employment, but often when you have any sort of conspiracy charge with drug trafficking, they're going to look around if any activity at all occurred within 1,000+ feet of a school zone. So it doesn't mean that any of this actually occurred on school property, but rather either it was transported and tracked, someone's house was within 1,000 feet that was involved in the conspiracy, and they will add that to the charge anytime they can. It's very common to see in any sort of multi-member conspiracy charge, if that helps at all. Mm-hmm.
To the staff, were you able to find whether the home that she lived at, was there anything in the record showed that drugs were trafficked to her home where she lived, which was in a school zone?
Not from the information that was submitted.
Okay.
That wasn't something we were looking for, though.
I have a question.
That helps me a lot.
Commissioner Norton.
Yes. Have you sold drugs? Have you ever sold any drugs?
No, sir.
Never. Have you used drugs?
I did use drugs.
Okay.
I was a user in the situation, if I must say, yes.
So, are you considered an addict? Still use drugs?
Oh, no, sir. I've been rehabilitated. Went to jail, went to the next door, which is down here. It was at Baptist Church right here downtown. The property set in front of there is next door. It's a girls' place for all women.
In an ongoing program for treatment now?
I do AA meetings often, but I'm not required to. I'm drug test every month for my probation. I'm still on, which will be done in December next year. I haven't gotten in trouble since.
Would the lady that came with you like to address the commission?
My name is Sarah. I'm the manager at Ride and Drive, and we actually met Miss Wimple about a year ago when she started detailing cars for us at our other car dealership. She had great potential, so we decided we wanted to try to move her up in the company. So she's doing administrative work right now for us. She's very sweet, very caring, likes to help people, but we kind of want her to try to grow with the company and move up even more, but she would need that salesman license to do so.
Last name again, ma'am?
Pinozo.
DeMozo.
Uh-huh.
Like she would be, you obviously think she'd be a good risk to your company, and we would be, the commission would be concerned about her interaction with customers, consumers, whether or not it would be her to interact with customers.
I'm sorry, what was that?
What, you feel like she's a good risk to interact with your customers and Tennessee consumers?
She does great with our customers. Yes.
This is Commissioner Melton. How long has she worked with you?
She has been with us at doing administrative work for about 6 to 8 months. I don't know the exact date.
She handles documents for you now?
She does like our title work, takes payments over the phone, and yeah, that's pretty much it right now.
I'd like to make a motion that we grant the license.
I'd like to second it.
Well,
Motion by Commissioner Vaughn to grant, and then there was a second, a couple of seconds maybe. Commissioner Melton. Thank you. Is there a discussion of the motion? There no discussion of the motion, so the chair would call for a roll call vote. Yes would be for the motion, and that motion would grant. No would not grant. Commissioner Director Shaw, thank you.
Yes.
Commissioner White?
Yes.
Commissioner Melton?
Yes.
Commissioner Lee?
Yes.
Commissioner Barker?
Yes.
Commissioner Fox?
Yes.
Commissioner Galvin?
Yes.
Commissioner Norton?
Yes.
Commissioner Vaughn?
yes.
Commissioner Jackson?
Yes.
Commissioner Kramer?
Yes.
Commissioner Evans?
Yes.
Commissioner Tomaso?
Yes.
Chairman Roberts?
Yes.
Motion carries to approve.
Ms. Whipple, you'd be granted a license. Congratulations. Good luck.
Thank you.
Good luck, lady. Have an appeal for Phoenix Wholesale. Morning, sir. Holstein.
Under the recent changes to Tennessee Comp RN Regs 0960-01-.08, which are now effective, the Commission may deny a dealership application for a corporately owned dealership if any manager, director, or owner of 5% or more of the company could be denied as an individual applicant under Tennessee Code Annotated 55-17-114. In this case, Mr. Sims, the owner, could be denied as an individual applicant because of his conviction of the promotion of the manufacturing of methamphetamine on December 9th.
I'm not Mr. Sims. I apologize. I'm Mr. Graham.
I've got an appeal for Mr. Sims then.
He's not affiliated with my company at all.
Is there anyone in your company by the name of Mr. Sims?
Mr. Sims not affiliated with Phoenix Wholesale in any way, sir.
Point of clarification is that he was or...
He never has been. I'm not sure who that gentleman is, sir.
Okay.
I have Mr. Graham in our...
I have Graham, too.
That's me, yes.
I apologize. I think I was reading from the wrong document. Excuse me. I'm sorry. Same information about the denial being applied to the individual, but my apologies. This is for the applicant of Mr. Graham in regards to Phoenix Wholesale. I apologize. I printed out a denial for Phoenix Auto Sales, so this is a different dealership. This is Phoenix Wholesale on behalf of Brian Graham. In this case, Mr. Graham, the owner, could be denied as an individual applicant because of his conviction of aggravated burglary on May 25, 2011. Mr. Graham received a sentence of 4 years of probation. Thus, his application for a dealership license may be denied under Tennessee Code Annotated 55-17-114A until May of 2020. Again, I apologize for the mistake.
Okay. This is an existing dealership, and you're applying to be an owner of that dealership?
Correct, yes, sir.
And be licensed as a dealer?
Yes, sir.
Okay, very good. Well, if you just give us a brief overview of the occurrences.
Sure. I've been in the car business my whole life since I was 21. I started selling cars at Reader Chevrolet in Knoxville, Tennessee. And I went to work for Rehabilitation Ford in Clinton. I worked for them from 2002 until 2008 when he sold out to a different company. And then I went to work for his cousin Gary. But in the process of working, doing finance for the Ford store, I started taking hydrocodones to give me energy because we worked a lot of long days and I'd get headaches. And anyway, I got addicted to them, physically addicted to them. And then Ray sold out, and I kind of went from making a lot of money to not making any money. And I made a decision to steal to support my drug habit. I was convicted in 2011 for that crime. And there's no, I mean, I don't have any excuse to tell you that there was any reason for me to do that other than I did it. So I've lost everything I had pretty much, like a lot of drug addicts will say. And then February 8th, I think, was the day I was arrested, 2011 in Knox County. and got 4 years probation and 582 hours of restitution, and I paid back $15,000 in restitution. I've completed all that. I completed all my probation, completed all my community service, paid back all my restitution. I've had no issues with probation. When I got out of jail, they dropped me off. I mean, I'll just know how to be honest. What they consider a halfway house on Magnolia, which they were using and drinking in every night. And I had the dirty clothes I went to jail in. And Gary Viles gave me my job back working with him. I had worked with him in 2009 and just slowly started building my life back. And, you know, I've completed that. I've got my rights to vote back, completed all the restitution, community service. I have some letters here, too, where I was required to do drug and alcohol assessment. I don't know if you guys would like to see them or not, but there's one from Cornerstone and Recovery in
Start them
Knoxville.
on this end of the.
Give them where?
Start them right over there, will be fine. We'll circulate those.
Yeah, I've got that one. And I've also got one from a continuing recovery that I do with a drug and alcohol counselor in Knoxville, Rico Hopewell of Hopewell A&D Counseling Services. I'm also involved in the Narcotics Anonymous in our area. I've helped put on 3 conventions that they do every year in the Knoxville area to hopefully help other addicts who are having issues with the epidemic that we currently face. I haven't used any drugs since I went to jail that day. It's the last time I used any drugs. I've worked pretty hard to get to where I'm at. When I originally applied for the license, I was under the impression that the felonies had to be 5 years old, which at the time they were because they were in 2011. And then we did everything, got the insurance, got everything set up, everything to the point to where you guys, or I guess the commission here could approve or deny it. They denied it based on the fact that the felonies hadn't been finished for 5 years. So I guess my completion date was 12/10/15 was the day that the state of Tennessee released me from their custody or supervision. And that's, you know, really all I got to go on is I'm begging you guys for your consideration for a license. I'm very experienced. I've held the position with Viles. I opened 2 dealerships for him while I worked for him, one in South Clanton and then one in North Clanton across from Ray Barner Ford, where it is now, which Ray Viles used to be. And I worked a lot of hours. We've got a lot of children. This is my wife. We had a little girl 9 months ago, and a spot became available where it's 5 minutes from my home. We can bring our little girl in there with us. We work, and have her there and don't have to miss the softball and baseball and all that stuff is the goal. That's the reason that I opened my own business. This is Betsy Boswell. She works with Viles Automotive. If she could say a word, maybe.
My name's Betsy, and I too have worked in this industry since '93, many years, seen a lot of things. I've worked with Dustin on and off over about 17 years. He has been at Viles with us since I started back there 2013, and he has not done anything other than be a loyal, trustworthy, hardworking employee, and we support him 100%. What he's doing now, what he's trying to do, and obviously Gary Viles as well, because I'm here. I'm the controller for his.
Who would own the other 95%?
No, Gary owns it 100%.
100%, okay.
Gary Viles.
Okay, I thought I saw something.
Not Phoenix.
Buying 5%?
Yes.
I'm sorry. I'm sorry I lost that last comment.
I work for Gary Viles Motors. I'm his controller. I've worked with Dustin for many, many years.
Okay.
He left us recently to open his own car lot.
Question was, who owns the other 95 of Phoenix?
It might not have come through, sir, on the
Moment, my father, Keith Graham, is the owner of Phoenix Wholesale, 100%. I'm seeking for your approval for me to be 100% owner in the company and hold the license as Brian Graham. I was denied just based on the, because I hadn't been 5 years finished.
would be eligible in 2020. Is that the right calculation? Okay. So you want to enter into your father's business, and you would be the owner?
Correct.
Okay. Thanks. I got lost between boss and...
All right, I apologize.
No, that's probably me. Okay. Further questions?
Yeah, Commissioner Norton, have you ever been incarcerated prior to this? Or,
No, sir.
Pardon?
No, sir.
Okay. Are you currently doing any kind of drug rehabilitation? Are you attending programs now?
Yes, sir. That's what I don't know if you heard me earlier say, in NA, Narcotics Anonymous, in the area.
Yeah, I heard.
I'm highly involved in their area. I'm their treasurer at the moment. We have a meeting once a month. They have a convention coming up in March, which is called CACNA, which is Knoxville Area Convention of Narcotics Anonymous. This is the 5th one we've had. I've been part of 3 of them so far, and then I'm also set on a board for Recovery on the Ridge, which we have every September out in Maryville, which is supported by Cornerstone, Steps House, Gelnick. A lot of the local treatment facilities attend that, and we just do, basically just try to be an example for others, and hopefully they're able to get a grip on their life, as I have.
Questions for Mr. Graham?
Second.
Motion by Commissioner Galvin to grant and seconded by Commissioner Norton. Is there discussion of the motion? Hearing no discussion, Chair calls for roll call vote. Yes would be for the motion that would grant. No would be to not grant.
Commissioner Levy?
Yes.
Commissioner White?
Yes.
Commissioner Melton?
Yes.
Commissioner Lee?
Yes.
Commissioner Barker?
Yes.
Commissioner Fox?
Yes.
Commissioner Galvin?
Yes.
Commissioner Norton?
Yes.
Commissioner Vaughn?
Yes.
Commissioner Jackson?
Yes.
Commissioner Kramer?
Yes.
Commissioner Evans?
Yes.
Commissioner Tomaso?
Yes.
Chairman Roberts?
Yes.
Motion carries to
Mr.
approve.
Grant, congratulations. Mr. Graham, good luck. Are there any more appeals, Ms. Shaw?
We have one other appeal listed on the agenda, which we thought would be in attendance, but I think legal may speak to that.
Sure. This is a matter that we had a respondent that did not fulfill their duty under a consent order. And so because of not paying the consent order, one of the agreements is that their license would be revoked after a certain amount of warnings and requests for payment. And that occurred here. And the dealer that only occurred last week. So the dealer didn't have the time, obviously, to put together the documents to reapply. But I asked staff, and they kindly added him just in case he was able to, in case you wanted to see it. But obviously getting zoning letters and things right after the holidays is difficult. So you may see this dealer in April in some capacity.
So would you consider this a no-show?
I would not. In fact, I haven't even told him that. When I spoke to him, I said there was almost no way that this was going to occur. Staff accommodated to add it just in case that application came in, but he didn't even know that I was anticipating he could. So I would not hold this against the dealer not being here today in any way.
So then it's not necessarily on the agenda.
We actually added him to the agenda because of the insistence, and we knew that he had requested an appeal, and this meeting was such a short notice. We did not want to create an extra hardship on the applicant. If he could possibly pull his documents together, we wanted to accommodate that dealer so that they wouldn't have to wait till the next meeting time. And it was almost, the time limitation was almost impossible from the time he was denied until now, but we wanted to make sure that we did not throw up a barrier that would prevent a person and make them have to wait longer to have it considered. But it just didn't work out for him this time. But I would not hold it against the applicant at this time.
Let me see just a moment. If it is it on the agenda that we approved this morning? But when I look at when I follow the agenda in the tablet, it goes from 7 to 9.
Well, it was on the documented agenda, but it was added at the last minute.
All occurred Friday.
The reason there is a spot there between 7 and 9 we held that in case he did get his application in here, so we would be able to present something to you guys for you to look at.
Well, would the commission be satisfied with no action? Okay. All right. Stand by on that one. Are you ready for the director's report?
Second to get my papers shuffled around. Last commission meeting in October 2017, the following activities have occurred. We've had 119 dealers opened or relocated during the last quarter. Active license as of July? January. We have 3,119 licensed dealers. Applications in process, 21. Distributors, manufacturers, 131. Auctions, 29. Representatives, 559. Salespersons, 16,439. Dismantlers, 271. RV dealers, 39. RV manufacturers, 65. Motor vehicle show permits, 5. We have had 149 complaints opened and 157 complaints closed. The annual sales reporting cycle is now underway, and it is the online submission process, the same as last year. We are working toward additional online services that will give the county clerks direct access rather than an old manual process that we've been working with for decades. So hopefully that will be available to them February 15th when the reporting period ends. Our metrics that were taken from our December CFG, or Customer Focused Government Report. Average number of days to license is 3.2 days. The productivity factor as indicated on that report is 108%, 108.1%. The CFG goal toward that metric is 235%. Compliance is at 93.9%. As you'll recall, that transitioned over to the Centralized Complaint Division last July. At that time, it was at 97.97. I think they're probably still leveling out that process a little bit. The Motor Vehicle Commission satisfaction rating, November 17 through January 2018, quarterly satisfaction rating was at 100%. Quarterly satisfaction rating combined with centralized is 98.9. Disciplinary action report, October 2017 through December 2017, there was $54,250 collected. Online applications across all professions, we are now at 71.43% online for all of our 1010, which is our initial transactions that are available online. I think that's an increase from, we were at, 50? I think at the last reporting, we were at 50 or 60% at the last reporting cycle, so we are showing a strong adoption rate. The remaining initial application types to be placed on the web are the motor vehicle, RV manufacturer, distributor, and the auto auctions. Obviously, that constitutes a very small population group of our application types, so it was kind of left to the end. But those requirements have been submitted to the IT group that's in development, so we anticipate seeing those soon. As of November 2017, the Motor Vehicle Commission is showing a slight deficit at $100,827, which this is our low year. It's a 2-year cycle, so in this cycle we do see a decrease. In the odd years, we do see an increase because we have manufacturers auction renewals in those years. As far as the outreach in the last cycle, I was asked to present and speak to a TASSER group on boat titling, which was a very interesting group of folks. I think that's something the state is exploring, probably a topic that's been discussed for a long time in the state. I'm familiar with that with some of my previous experience as well, and the possibility of licensing in some capacity. I think they have a report that's due out just any time, so when that information is available, I'll be glad to share that. Also, the TAA was very helpful in helping to share some information about the annual sales reporting cycle, just to help encourage the dealers and help get the word out. We always try to partner with the auctions or the professional groups to help share that information, make it easier for the dealers. Also, would like to note that that Commissioner Parr has submitted his resignation from the commission, and so we will be taking the proper reporting steps for that position. I think he had some health concerns and professional concerns, personal concerns that he needed to address. One last thing I would note for you is that as part of our last sunset audit, we are required to send or to keep track of all attendance, and last year we sent notification letters to everybody to let you know what your standing is. As far as I'm aware, I think all of our commission members are in standing. We have a very active board, good attendance, and so, but you will be receiving a letter in the next probably 30 to 60 days telling you what your standing is, but I'm not aware of any concerns. Mr. Chairman, that concludes.
Ms. Shaw, will Commissioner Parr receive a letter of gratitude from the Governor's office? Or,
he will, yes. Okay. He will receive a letter of gratitude and any other action that this body would like to take in recognition of his service.
Very good active member and a thoughtful individual, so we appreciate his work here. 71% online applications for salespersons licenses.
It's a combination of all of our what we would call a 10-10. If it's in anything that would be a barrier to putting someone to work, so that's the ones that the department measures as part of the customer focused government goal, is a new application, like a new salesperson's application, a new dealer's application, a new dismantler. Those application types are measured so that we can ensure that we're getting people into business and to work as fast as we can. And so the number that you have is evaluating the number that are coming in online, which obviously helps to expedite the process.
Is it reasonable to hope for 100%, 90%? Is there a level that we might attain?
I think
realistically attain?
I'm not aware of a ceiling right now. We were trying to move everyone as much as we can to online. However, we all realize there are parts of the state that don't necessarily have access, or for one reason or another they cannot do an online application. So in those situations, we do accommodate those individuals, and we do try to partner with the county clerks, as in with the annual sales report. The way we've handled that is it's all online, and we do notify the county clerks and supply them the written documents. So they do work with us as a partner in that regard, in several situations, as a matter of fact, and to try to accommodate that population in the communities where they know they're able to help them and get the additional assistance.
Fax is not considered online.
No, a fax is not.
Okay. All right. And comment, congratulations for 100% satisfaction for the commission and 98% combined with central complaints. So our congrats to the staff. Questions for Ms. Shaw regarding her report? No questions. Chair will entertain a motion for approving the director's report.
So moved.
Well, very plentiful right here. Parker, and I heard it seconded by
Second.
Commissioner Vaughn. Any discussion of the motion? Hearing none, chair calls for a voice vote. All those in favor of the motion to accept the director's report say aye. Aye. Those opposed say no. Motion carries. Thank you. Legal report, the legal report, yes. Sorry, Ms. Goldstein or Ms. Page? Ms. Page.
Morning, members of the commission. We reviewed the legal report in our subcommittee today. I think many of you, many of you were in the room. There should also be a supplement in front of you that's about 10 cases long that was not included in the materials that was sent to you ahead of time. We appreciate your patience with that between snow days and investigations coming in late due to illness and other reasons. We had a couple extra cases to add. However, at this time, Shalina and I are here to entertain any questions you may have, but we also did have a few changes to the legal report. I think that I'd like to note case number 7, the penalty for the dealership in this case was reduced to $5,000 at our committee meeting, down from $10,000. I think that was one of the more significant ones. Additionally, there was an discussion case in our response section. I apologize. I had it flagged, but then I unfolded it because I forgot why I flagged it. Number 14, that's it. Number 14 was a duplicate case, so we're going to be removing that. We thank Mr. Jackson for catching that for us. Additionally, we had a case for discussion that is, here it is. It's on page, well, I have different pages than you, so I'm going to tell you the case number. It's case number 92. I put that case on for representation for discussion, and our committee voted to do a $5,000 penalty as well as a follow-up investigation down from revocation. And those are some of the adjustments that we made. But if anyone noticed anything in the cases, whether that's a question for us, whether it's commentary or, on how we proceed on different issues or anything that you'd like to discuss, please let us know, and we'll do our best to answer your questions. That's right. We added flags as well to 64 and 69. Thank you so much, Commissioner.
Motion by Commissioner Jackson to approve the legal report and seconded by Commissioner Vaughn. Thank you. Discussion or concerns for the motion?
I'd like to add the supplement to that motion, Mr. Jackson.
I'd like the amendment to add the supplement report.
I appreciate you. Thank you.
Commissioner Jackson makes an amendment. Commissioner Vaughn accepts the amendment. All right. Those in favor of the motion to approve the legal report would, by voice vote? Voice vote. Okay. We'll say aye.
Aye.
Those opposed say no. Motion carries.
Thank you so much, members.
Business.
The next agenda.
Statutory references for salespersons appeals. That's on.
Oh, those were the references that you used earlier to look at when you were discussing motions.
The next items you had was just committee reports, but there's no other activity under the committee reports at this time. And then you move into the new business category at that.
Don't have any on the agenda. I would like to take a moment. I've been advised that we may have an interested party that might be attending motor vehicle meetings in the future, and Mr. Noble might know something about that. Do you? Would that be an occasion you'd like to make a? Yes, please approach the podium.
Commissioners, well, after 12 years of being the director of the Auto Dealer Association, I've resigned at the end of the year, and it's been a pleasure working with Commissioner Roberts and the rest of you guys. And we have found, after searching for 6 months, trying to find a director that would be suitable to carry the association on, is Director Phyllis Sarton. She's been in the auto industry for about 15 years in various roles, marketing and different things like that. She's also been a board member of the association. And I feel that, you know, and the board does too, that she'll be able to carry this on and work with you guys and, you know, keep hopefully the used car dealers in line which is a task in itself. And but I just want to thank you guys for all the time that, you know, the relationships that I've built with you guys over the last 12 years. I've seen a lot of commissioners come and go and directors come and go, and it's been a pleasure. And I'm looking forward to getting back to my RV dealerships, because this takes a lot of my time, and I really need to spend more time doing that. And my franchise stores are busy this time of the year. So this time I want to introduce you to Phyllis Sarton, and she's our new director of the Tennessee Independent Automobile Dealers Association.
Sarton, welcome.
Hi. Thank you for having me today. I want to first thank the TNIADA board and Daryl for having the confidence in me to take this association over. I know that Daryl has been up here representing the independent dealers for quite some time, and I do look forward to following in his footsteps. I want to thank you all, and I look forward to working with you as well. Thank you.
Martin, welcome, and congratulations. Mr. Noble, thank you for your contributions and that of the TIADA. Your involvement and your interest and your advice has been very, very important to us. Thank you. Thanks. Okay. Anyone else from your board? Another gentleman back there, would he like an introduction? Is this gentleman from your board?
This gentleman is one of our board members, Bob Gallucci. He's
Gallucci,
also,
good morning, sir, and welcome. If you'd
with
like
one
to
of
address
the
the commission briefly.
Companies.
Welcome to.
Just say
Hi, my name is Bob Gallucci. Not too close, I guess. Sorry about that.
You're fine, sir. Go right ahead.
Okay, I am an independent agent for finance and insurance companies for the last several years. I moved to Nashville 4 years ago. I worked for a company that employed her husband, so I got to know Phil and Phyllis. And what a great couple, and a great gal to run your association.
Thank you. Also,
thank you.
You're on the committee.
I am on the board of the association.
The contributions of your board and TIADA.
Thank you,
sir.
Thank you very much.
Thank you. Okay. Ms. Shaw, check me for errors and omissions here. And
we have no old business. We have.
Just a quick update on the rules that the commission passed back in October, the salvage disclosure rule. I just wanted to update you with the good news that has been moving very quickly through the rulemaking process, and on January 3rd was submitted to the AG for a final approval signature. Once we get that back, then we will be filing it with the Secretary of State. So.
Thank you. Thanks to our legal department and the Rules Committee for your work on that legislation. Oh, here no more business. Chair would entertain a motion to adjourn. Is there a motion to adjourn?
Second.
Action seconded. All those in favor of adjournment say aye.
Aye.
Those opposed say no. Thank you all for your attendance.